Hey there, it's me by birth, Alex William Smith, better known as Jonathan Royal Hypnotist. In relation to my fake Sheikh Mazher Mahmood related unsafe convictions, you can get the full story at circusofthemind.net. There are numerous reasons, as you will see at that website, why my convictions are unsafe, and the evidence of those literally dozens of different reasons, and I've got dozens of witness statements and evidence galore, videos, audios, photographs, documents, you name it, which have been passed to the Criminal Cases Review Commission on the 3rd of February 2026. But one of the many issues is the disclosure failures by the police and CPS, which are explained a little bit more in this video. So, the precise question that I've asked ChatGPT and also OpenCase, which is the legal kind of version of AI, is specifically word for word, please tell me exactly which part of the Criminal Procedure and Investigations Act 1996 would have applied to the fact that the Crown Prosecution Service should have told me before I went to court in 1999, after being arrested in 1998 based on a story by fake Sheikh Mazher Mahmood that they at the CPS had written to the Met Police in 1994 after the collapse of a court case where Mahmood was the main witness and stated to each other that he could not and should not ever be relied upon as a witness of truth ever again. Also, they never told me about any of the 3 cases that collapsed before my trial, another 3, making 4 in total, and have never disclosed to me since then, to the present day, the total of at least 12 trials that have collapsed over the years due to his perjurious lies and tainted evidence. Had I been made aware of such prior to my March 1999 trial, I would never have changed my plea from not guilty to guilty on the first day of trial. For the record, at the end of 2025, the CPS stated in writing to me that they had no intentions of ever disclosing anything to me about Mazher Mahmood and past collapse cases. Well, they never have done at any time, despite the fact that they should have done under the Criminal Procedure and Investigations Act 1996. A key being Section 3(1)(a) requires the prosecution to disclose to the defence any prosecution material which has not previously been disclosed and which might reasonably be considered capable of undermining the case for the prosecution or of assisting the case for the accused. And how this applies to my situation apparently is quite simply that there were prior collapse cases involving Mazher Mahmood, internal CPS and Met concerns about his credibility, including the 1994 correspondence I mentioned, and a pattern of unreliable or dishonest conduct as a witness. And apparently that would very likely fall under material capable of undermining the prosecution's case. Indeed, it goes on to state, if the case against you depended significantly on Mahmood's evidence, well, he was the witness, his known unreliability is classic undermining material under Section 3 and should have been disclosed to me. Under Section 7(a), they have a continuing duty. The prosecution has a continuing duty to disclose material as it arises. Well, they did in 2014 after the collapse of the Talisa Kontostavlos trial, send me a little bit of a disclosure package about what happened in the Talisa case, but they never took that opportunity to tell me about all the other collapse cases and instances where they were aware of Mahmood's dishonesty and perjurious lies and tainted evidence. And indeed, as I say, in late 2025, they stated in writing they had no intentions of disclosing anything to me at all. And yet, even if something wasn't disclosed pre-trial, the CPS's and police's duty of disclosure continues during and after proceedings, and yet they've continued to fail in that for decades. Ultimately, it means that the police and CPS breach the CPIA Code of Practice. You can see the details of that on screen, but ultimately they should have disclosed to me credibility issues with key witnesses, previous failed prosecutions involving the same witness, and internal doubts about reliability. In other words, the documents that exist showing that the Met Police and CPS communicated in 1994 stating Mahmood should not and could not ever be relied upon as a witness of truth ever again are pivotal in proving and showing that my convictions are and always have been unsafe. Indeed, the fact that these things were never disclosed to me means that fair trial rights under Article 6 of the European Convention on Human Rights were also breached. It seems the legal test is the important thing, and namely the key legal threshold under Section 3 is might reasonably be considered capable of undermining the prosecution case. Would the things that they failed to disclose to me be considered capable of undermining the prosecution case? Well, this is a low threshold interpreted broadly by the courts. Evidence that a key witness had been previously deemed unreliable by the CPS itself, had caused multiple case collapses, would almost certainly meet that test, thus meaning my convictions are indeed unsafe because I was never given the opportunity to a fair trial. And it is true that the CPS knew and had documented, recorded communications between themselves and the police that Mahmood was unreliable. They had internal communication saying he should not be relied upon. They knew of multiple collapsed cases, and yet they did not disclose any of that before my trial, and they haven't done since. That does amount to a serious breach of Section 3 CPIA disclosure obligations. Because I did not have this information, which should have been disclosed to me, on the first day of trial, I changed my plea from not guilty to guilty with mitigating circumstances. And the thing is, in law, a guilty plea may be considered unsafe if it was entered without knowledge of material non-disclosed evidence, and that evidence could realistically have affected my decision. Courts have accepted that non-disclosure can invalidate a guilty plea in some circumstances. One of the main ones being that I did not have available to me the information which would have enabled me to show that Mahmood should not and could not be trusted. As I say, I contacted the CPS numerous times over the years, most recently at the end of 2025, and in writing they categorically said they have no intention of disclosing anything to me. ChatGPT says that I should contact the Criminal Cases Review Commission. Well, as you can see at circusofthemind.net, I did exactly that on the 3rd of February 2026. Opencase.com, which is the legal AI, says much the same. The key point being that if the CPS or police disclosure officer knew before your 1999 plea, which they most definitely did, that Mazher Mahmood had previously been the subject of a collapsed case and had been described internally as someone who could not and should not ever be relied upon as a witness of truth ever again, that is exactly the sort of information that would ordinarily be treated as material relevant to the investigation, and if it could reasonably assist the defence or undermine the prosecution, material that should have been disclosed under the CPIA regime and code of practice. Well, had it been disclosed to me, I would have continued to plead not guilty, gone to trial, and been able to expose Mahmood's long-term perjury, and would never have gone to jail, as explained at circusofthemind.net, so my convictions are unsafe. It seems that the main practical legal point for my 1999 court case is if the CPS and or police had in its possession, before my plea, material showing that the witness, namely fake Sheikh Mazher Mahmood, had previously been found unreliable, earlier cases involving him had collapsed, the CPS and police had internally concluded he should not be treated as a truthful witness, then the likely CPIA 1996 regulations question is whether that material might reasonably be considered capable of undermining the prosecution case or assisting the defence. And open case, the law AI says on your description, the answer would strongly tend towards yes. As Paddy French exposes in his article Rupert Murdoch's Fake Sheikh Tainted Evidence, dated 12th of November 2025, available on his Substack, the simple fact is there were over a dozen cases that have collapsed due to his perjurious lies, none of which the CPS or police ever disclosed to me at any time up to the present day of making this video on the 30th of March 2026. So there you have it. For more details, go to circusofthemind.net, where you will get links to various things, and also, of course, be sure to check out Paddy French's Substack articles and his book Rogue, The Rise and Fall of the Fake Sheikh, co-authored with Roy Greenslade, within which they expose the many cases the police and CPS were aware of and yet never disclosed to me or other victims, and never have done up to the present day.